Thanks for joining us on 9 News Plus. I'm Chris Bianchi. The Supreme Court is hearing arguments about the potential cancellation of President Biden's student loan relief executive order, which he first issued last summer.
If you earn less than $125,000 a year, you'll get up to $10,000 knocked off your student debt.
Will it get struck down by the nation's highest court? 9 News legal expert Whitney Traylor joins me, Chris Bianchi, for more about what might happen. Thanks for joining us here, Whitney.
It's good to be here.
So I guess the big thing when it comes to this case on the top line basis, before we kind of get into the nitty-gritty details, which there are plenty of, give us the kind of overview of this case. Who's arguing for, who's arguing against?
Right. So it's an interesting case, and it's actually two cases that the Supreme Court is hearing, which is not unusual. The Supreme Court is the supreme law of the land, and so a lot of times when the court accepts a case, because you don't always get in front of the Supreme Court, you have to file a writ of certiorari. And to get in front of the court will look at, well, is there a split in authority? So has one court ruled this way and another court ruled this way? And so the Supreme Court will accept the case and then resolve it, because what the Supreme Court says is going to be binding on everyone. And so here there were two cases that originated out of different states. And so one was by 6 Republican attorneys general that were suing, saying that President Biden didn't have the authority to wipe away this amount of debt without involving Congress. Well, the second lawsuit was 2 students. One student had a private loan, and so she was saying, hey, I'm being precluded from this benefit. And so the issue in both of those cases was, one of the major legal issues was standing. Did the attorney generals have standing to sue? Have they been harmed? And then the second question is, have these students been harmed? Because they have a private loan, and the fact that that wasn't waived doesn't have anything to do with it. So that was the issue. The real issues, the difficulty on the plaintiff side, or the folks challenging it, is really the standing issue. Have they been harmed? The real difficulty on President Biden's side is, does he have the authority to wipe away this debt? And I can talk to you about the statute and some of the intricacies of that, but that's the kind of primary issues on both sides.
It's pretty interesting. This is going to have, by the way, for our audience, we'll have a bit more on this as we go on, but this has long-term ramifications for the scope of not only President Biden's power, but future presidents' power. We'll get into that here. So that's, again, one of the reasons we did want to tackle this issue in detail. Obviously, we're talking about student loan debt. This is being based on constitutionality, a document that was written in the late 1700s.
Right.
So what does the Constitution have to say about this, or what can we glean from it?
Right. Well, it's interesting, because this is one of the things I always tell my students, is the framers were geniuses in a lot of ways, in that they created a constitution that would still be applicable 200 years later, when they couldn't anticipate the technological advances, the societal advances, but it still works. But one of the fundamental tenets of our constitutional law is that we have 3 equal separate branches of government. And really this is kind of sets that fight up, because here, under the HEROES Act, which was passed after 9/11.
So 2003, I think it passed, right?
Correct. It may have been 2003, but it was after 9/11, and the purpose was primarily for service members who were in Afghanistan and Iraq. And it allowed the Secretary of Education to waive or modify terms of federal student loans in connection with a national emergency, right? And so here, this is, if the Secretary of Education has this authority, what they can do is the president can say, okay, Department of Education, waive or modify these loans. And so the argument that President Biden is going to make is, or that he did make, is that we're in the pandemic. Because of the pandemic, people couldn't pay back this debt. The pandemic's going to have long-term effects, and therefore we are going to cancel this debt, because it's going to be an ongoing thing, and we're in the pandemic until at least May 11th, because they said they've declared
the national emergency.
Correct. And so one of the arguments is, well, is canceling the debt waiver or modification? Because remember, the secretary can only waive or modify the student loan debt. Is cancellation a waiver and modification? So that's something that the Supreme Court will decide.
It's an interesting case in a number of different ways, but I guess before we gotta get a bit more into some of the long-term ramifications about this, can we glean from the justices' questions? It's often something that happens. Can we glean where they may be headed with this?
Well, the conservative justices were definitely questioning whether President Biden had the authority, and it was John Roberts, Chief Justice John Roberts, that actually made a good point, in my opinion. He said, look, first of all, you didn't give the people an opportunity to comment, even though this was an administrative act. So people couldn't comment on whether or not they wanted these debts canceled. And then he's saying, and then you didn't involve Congress because they did this under the HEROES Act, so the Secretary of Education. And then they said, now you're coming into court saying, hey, these people who are challenging it don't even have standing. So now the courts won't even be able to rule on the merits, because if they rule they didn't have standing, then they don't even get to the merits of the argument, because procedurally the parties didn't have a right to be there. So Chief Justice Roberts was suggesting, hey, you haven't involved anybody. We don't have a king anymore. We don't want you to be able to waive, this is going to amount to what, $400 billion over the next 3 decades. But what's interesting, though, is President Trump used this same HEROES Act to waive the interest payments. So even though he wasn't pushing to get the debt canceled, the interest payments are being waived, and that's $5 billion a month in interest payments. So, and that's been ongoing for 2 years, and those interest payments are still being waived. So, so the conservative justices were questioning, hey, this is a lot of money for the president to be able to just waive with, kind of a magic wand, if you will. And the legal issue is, they call it the major question doctrine. And if this is a major question, then Congress has to get involved, and because Congress controls the purse. So my sense is that the conservative justices and the conservative majority is going to rule against the Biden administration. But I don't know how they're going to deal with the standing issue. I mean, as a matter of law, the standing issue, were these plaintiffs harmed, is going to be a real issue, because if they can't...
So, the attorneys general themselves were not harmed directly by this. That's the point, right? That's the standing issue.
That's exactly right. And the state itself wasn't harmed, right? Because you had people in the state, some people's debts were waived, other people weren't waived.
Yeah, it's all red state, so it's a political sort of thing, right?
But they can't show, hey, here's how my state is harmed by this. Now, one of the ways they said Missouri, which is one of the states suing, their Department of Education, one of the justices was saying, well, that Department of Education, or their higher education department, could have sued because it was loans that would have impacted their department, but they didn't sue as an entity. It was the state itself. So that's going to be a tough issue. I'm really curious how the justices are going to rule on the standing issue.
So kind of break it down maybe pretty simply and succinctly,
Succinctly,
which
yeah.
I can't say clearly. The case here, it seems like there's perhaps a pretty good legal merit on the fact that there was no involvement from Congress or from the public on this executive action, but the Supreme Court usually will only take up cases if it's somebody directly being, or a body being directly impacted. In this case, that may be difficult for them to prove. Is that a simple way to put it?
It is. I'd make one caveat. It's not just the Supreme Court, so it's any case. So this happens a lot of times with taxpayers. So if the IRS changes the code and a taxpayer comes in and sues the IRS for saying it's unconstitutional, a lot of times those are dismissed because the court, even at the trial level, will say, hey, taxpayer, you're not actually harmed by this provision. It doesn't impact you specifically, so you don't have standing, so you get kicked. So here, it was actually the lower court said that the students didn't have standing, but wouldn't, they essentially stayed the imposition of the waiver of the debt. Essentially, they said, hey, we don't think you have standing, but we're not going to let the debt be canceled until the Supreme Court rules on it. So they put a stay on it. So that's why, so there's 26 million students who are eligible or who have applied, 16 million have already been approved. And so they're just waiting to hear, once the Supreme Court rules on it, which will be June or July.
June or July. So we'll find out in a couple months about this. We mentioned what the conservative argument may be, or based on the attorneys general, what they're arguing. What's the defense on this?
Well, the other argument is primarily the standing argument.
Standing,
yeah,
okay.
And saying that, hey, these folks didn't have standing, and they're saying, look, under the HEROES Act, because Congress passed the HEROES Act. So that's the argument, is that, look, this was a statute that Congress passed, and you specifically gave the authority of the Secretary of Education to waive or modify these debts in a national emergency. That's a strong argument. I mean, that's an argument that, yes, Congress, you gave us this authority. Now they're going to say, well, we didn't anticipate you waiving, all student loan debt, for every student who was under $125,000.
So I'll make the devil's advocate arguments for both sides here. To me, when I hear the argument about the national emergency being the pandemic did not necessarily cause student loan debt in most cases, right? So doesn't that seem like a loose interpretation at best?
Well, it doesn't have to...
especially with the interest being wiped away, right? So there was no interest accumulated. It was basically a debt. The debt continued with no interest accrued, right?
That's a great point. But when you look at I think the counter to that would be the effects of the pandemic were not just isolated. They're still ongoing. The economy hasn't recovered. Certain parts of sectors of the economy haven't recovered. So, and that's why they're saying, look, this is specifically for students who make $125,000 or less, which is a lot of money, but in the scope of salaries and income in this country, $125,000 is, I guess middle income. It's gotten so expensive in Colorado. I don't know if that even be, that's low to middle, I guess. It's just gotten so expensive. And that is the argument, that this, and by waiving this is the idea. I don't think anybody used the phrase trickle down, but the notion is, hey, if the students don't have this student loan debt, they're going to keep going in the economy, they're going to contribute to the economy, and everybody's going to keep consuming, and we're going to keep going.
I guess the flip side, devil's advocate argument, would be maybe against some of the conservative justices, what they're saying isn't a little hypocritical, because at times they've supported or they've dismissed similar cases in the past, haven't they?
Well, it's the same. That's the argument. Some people saying, look at the PPP loans, that, these are companies, these are businesses that have the ability to generate revenue. That's the whole point of their existence. Yet they got millions and billions of dollars in loans for purposes of paying salaries, and those were completely waived without an issue.
Interesting. So I guess this will have a pretty good ramification potentially here on the scope of executive power. Is that not right?
That's exactly right. And see, some people would point to President Obama and say he did so many executive orders and he was expanding the scope of the administration. And then you look at President Trump, who came in and he completely pushed the bounds of the office, including eliminating a bunch of offices and consolidating power within the executive, and was constantly challenging. I mean, this was a beautiful time to be a student of the law, because he was always challenging it. And these are things like January 6th, we've never had a former president be convicted. These are all things that are happening for the first time, and we're a relatively new country in a broad perspective. So this is how our law evolves. This is our common law system at work, developing precedent. So some of this, with President Trump, a lot of this played out. Who had authority? And this is going to be an issue when he's being subpoenaed. Can Congress subpoena the president? Because then he'd be subjected to their power. So are they co-equal branches? So all of these things are issues that the court is going to have to decide. And this is why, in this age of such partisanship, when historically the judicial branch, the public has had confidence in, they don't have that confidence in the executive and the legislative branches. But now the confidence in our judiciary is even being eroded to where less than a majority have confidence in the judiciary. And that I'm making an aside, but that's critically important, because if we don't have anybody that we trust to decide our disputes, then that does lead to anarchy. Like if you say this is the arbiter, this is the person who's going to make the decision, and then you fundamentally don't believe in their decision, right? Then there's that erodes at law and order, and so having less faith in the judiciary is a problem.
How do you have trust in the outcome of a Broncos game if you find out that the ref's a Raiders fan or something like that, right? Yeah,
exactly right. And that's why our confirmation hearings, which have gotten completely partisan, I think is a huge issue with that. Because you look back at, for example, Justice Scalia and some of the other liberals, and they got confirmed almost unanimously, 20, 30, 40 years ago. And now it is almost completely partisan. So it's a problem. And that's an aside, but it is relevant to this issue of how we're going to govern. I mean, the Constitution was developed, one of the main points was 3 co-equal branches of government, and to also limit the federal government.
And it seems like that's certainly going to be a case here. I guess when it comes to all this, if let's say it's overturned, aside from the fact that people who are hoping to get those student loan, that relief canceled, that being obviously wiped away, what would be other ramifications if the Supreme Court goes ahead and does away with those?
If the Supreme Court doesn't allow the debt to be waived?
Yes.
Yep. Then, so this will be, and they've I guess announced that after the decision, it will be about 60 days before payments will resume. So I would tell folks who have already been approved or who are waiting to still be financially prudent, try and save money while you can, while you still have a few months. In the event that the debt is not waived, you don't want a bunch of people now in financial peril. And
based on what you said earlier, it sounds like your lean based on those questions would be that the Supreme Court may strike it down?
Yes, I'm cautiously predicting that I think they're going to strike it down. And the only reason, the primary reason I'm cautious about it is the standing issue. I don't know how they're going to address the standing, because if these parties didn't have standing, then you don't even get to the second question of the merits.
Interesting. Any final things to add on this?
No, I think this is, this is interesting, and this is good. This is how our, American jurisprudence system works. Our democracy evolves is by, pushing on the boundaries and figuring out the give and take. And we've had a lot of this with, of course, the Dobbs decision in terms of the state and federal push, which has always been an issue with the state and federal. And now you have these federal administrative agencies and the federal branches figuring out their power. So it's a power struggle, and there are legal arguments on both sides. So it will be interesting to see how they rule. And we'll come back and chat about it in June or July.
Yeah, June or July, right? That's when we'll find out.
That's when we're anticipating, yep.
Okay, so we'll find out June or July. But in the meantime, as always, thanks for joining us here on 90s Plus. 90s legal expert Whitney Traylor.
All right, thank you.